Start recording now. Great, thanks for being here. What we're discussing today, essentially, today the break is kind of methodologically very clear because we're really covering two very separate topics in international refugee law. One is the exclusion clause, so Article 1F of the Refugee Convention, and the other is what many people, including myself, would call the Contingent Inclusion Clause, which is the provisions specifically applying, although in the language of the provision, not using those terms, to Palestine refugees, which is Article 1D of the convention. So we'll run through however long the first kind of section will take us with 1F. Then we'll do the proper break for lunch, and then we'll lunch in my case, not for you quite mid-afternoon or whatever it is, and then we'll resume for Article 1D. So let me share my screen. Hopefully, you'll all be able to see it. As usual, if you can't, let me know. So this is where we are in the module. So you'll be pleased to hear we've passed the halfway point, which is good. Um, and what I want to try and cover today are the following components in relation to Article 1F, and I'll do a similar kind of structure description when we come to Article 1D. I want to talk about the difference between exclusion from refugee status and expulsion, right? Those are two different concepts. One applies at the entry point to the state, right, where a refugee is being assessed as to whether they should be recognized as a refugee. Expulsion happens by definition at the point where the person is already recognized. So I want to explain that distinction between ultimately Article 1F and the provision in the Refugee Convention that speaks to exclusion, which is Article 32. I then want to talk about the objectives of Article 1F. So what is the point, to put it bluntly, of having a provision that excludes certain people who otherwise would meet the refugee definition from its protection? Well, why did the drafters think that that's a sensible thing to do? Do you think it's a sensible thing to do? Right. So that'll be the next phase, and then we'll start looking at general principles of the application of Article 1F, and specifically at the question of proportionality. So, and I think every time kind of raise that question of the relevance of proportionality in different contexts of refugee law. Here, the provision itself says nothing about proportionality, but there is perhaps a sense of unease at applying it without any due regard to the effects of exclusion on a specific individual being excluded. Hence, the recommendation, at least by UNHCR, that proportionality does enter the equations. Again, it's an interpretive question, given the provision says nothing about it, whether it's a sensible thing to have a measure of proportionality applied to Article 1F. And then I want to look at this three specific sub provisions of Article 1F. The perhaps most defined of the three being Article 1FA, which speaks about specific international crimes, which certainly today have definitions. When this convention was drafted, that was not fully the case. But today, all of the components of Article 1FA have equivalent international definitions. So it's an easier provision to apply, albeit still subject to the same overall problems that we've exposed about subjectivity and diffusion in previous seminars. 1FB is a much more complicated provision because its application requires passing judgment as to the activities the person was engaged in in their country of origin. And that passing of judgment is inherently, subjective, as we saw in relation to questions around membership of a particular social group. And I will illustrate this not actually with a case around sexual orientation or gender identity or gender or sex, but rather with a case that you might remember. I mean, you were all, I think, adolescents, but he might have entered your radar, and that's the case of Edward Snowden, an American who leaked to newspapers information about the U.S. Undertaking various surveillance operations that were unlawful, and ultimately having had to flee. In his case, initially to Hong Kong, but ultimately to Russia. And so the question whether Edward Snowden should be where a country where you to be a decision maker, whether someone like Edward Snowden in his position should be excluded from refugee status. Alternatively, should they be granted refugee status in the circumstances where he's being charged with certain crimes in the United States, or whether neither of those is actually suitable in his case. That will be the case study I'll use to illustrate some of the challenges of Article 1 FB. And then finally, Article 1 FC, which is perhaps the least defined of the provisions, talking about, as you will see, the principles and purposes of the United Nations, and raising the classic kind of adage of one man's terrorist, the other person's kind of freedom fighter, being a real life challenge in the application of Article 1 FC, because terrorism offenses tend to be the most common situations in which Article 1 FC is being applied. So that's the overall context for, well, I assume the next hour and a bit. We'll see if we need to do a very short break during it, but potentially we'll just run the course and then have a break for before we move to 1D. Any questions thus far from anyone? No. Okay, so this is the provision. The provision says a person with respect to whom there are serious reasons for considering that he or she has committed a crime against peace, a war crime, a crime against humanity, as defined in the international instruments drawn up to make provision in respect of these crimes. So I will come to the specifics of the provision, as I said. I don't want to dwell too much on each of these components. We'll come to them, but I just want you to notice some of the language that's being used. The standard or the benchmark that's being used is having serious reasons for considering that someone has committed something, right? And in the second provision, it has committed a serious non-political crime, which had to happen prior to admission to the country as a refugee. And in the third, for some reason that I could never really fully understand, I mean, there's no clue in the drafting of the treaty and the travaux préparatoires as to why there they chose to use the term has been guilty as opposed to has committed, because guilty presupposes some sort of a trial having happened, which the other two don't necessarily require. Um, and the third one being has been guilty of acts contrary to the purposes and principle of the UN. What is the first thing you noticed about the language, about the temporal dimension of this provision?
Wait, what's the question again?
So what's the first thing that you noticed about the temporal dimension, about the time at which this provision is referring to? So, and how does that differ from refugee status itself and the kind of premise or prism we apply to that? So which tense is this drafted in? I
It's a
mean,
past tense.
exactly. So this is a provision that is backward looking, right? So we
Yeah.
said refugee status is forward looking, right? Refugee status asks the question, what will happen to the person if I return them. But that provision is being now balanced in a certain way in the convention by qualifying that assessment of what would happen to the person if I return them based on what they have done in the past, right? And all of these
Yeah.
instances have to have already happened by the
No,
time
it's
you enter. Sorry, go ahead.
I mean, yeah, it's interesting because it's also as far as at least this article goes, maybe there are more that considers, but it doesn't look to the future in the sense that it doesn't say if we it is probable that he will commit more crimes in the
Hmm,
future,
sure,
then he won't get asylum. Only
sure.
if he already did it, but we know that many people there's a good chance that if they are part of this organization, even if they didn't committed this, yeah, they will commit in the future.
That's right. So the interesting thing is that we talked yesterday about that proviso to non-refoulement, right? We said that Article 33(2) of the Refugee Convention allows you, in principle, to send people back without even assessing fully their asylum claim if they pose a danger to the state which they've entered. As we saw, there's a difficulty in applying this provision, given that there may be other reasons for the person to not be sent back under human rights law, and those are not qualified. But there, in Article 33(2), there is that future dimension, right? The convention essentially said in those circumstances, there's a certain amount of risk that the state may choose not to take. And the grounds for thinking that somebody may pose a risk are his past activities, right? So if we go back to the language of Article 33(2), it talks about somebody having previously committed a crime, they now are deemed to pose a danger to the state. So what you're describing is present in the convention, but not in relation to exclusion. So the point about exclusion is that it is the actions that you've committed in the past that are deemed so grave to potentially deny your refugee status, even if you wouldn't commit any further crimes, right? So even if it is the case that somebody's committed very serious crimes, let's take a case that I don't think would be controversial under 1FB, although, as I said, I want to come to the more controversial stuff later. Somebody who's, committed, who's raped several children, right? 10 years ago, right? So let's say there's no reason to assume that rape again necessarily, but it's that heinous crime in its own right or wrong that is deemed to deny that person refugee status, right? So that's the framework, and it's in that sense backward looking. There's a second thing that's interesting about this provision, which is who bears the burden of proof in this provision. So who do you think needs to demonstrate that Article 1F applies compared to the refugee definition itself? So where does the initial burden of proof lie with the Refugee Convention? We haven't talked about this actually explicitly.
It
So
seems on the country that refuses.
so in 1F, that is exactly right, right? So in when you want to exclude someone, it is the decision maker, right? The country that needs to come up with, as it were, serious reasons for considering that that person needs to be excluded. We'll come a bit later to what is the standard of proof. But the reverse is true about the refugee protection itself, right? So with refugee protection, our starting assumption is that the burden lies with the applicant, right? Again, we haven't talked about the levels of burden of proof actually in that relevant seminar, because it's again an undefined thing in the Refugee Convention. But the starting premise globally, right, is that people are enjoying the protection of their states, right? So you start from a presumption of protection, and in order to rebut that presumption, an individual has to demonstrate that they have a well-founded fear of persecution, right? So the starting point in refugee protection is a burden falling on the individual. The starting point for excluding an individual from protection falls on the state, because the starting point here is that person needs protection because they are a conventional refugee, and the state wanting to deny them protection under Article 1F needs to demonstrate why it has serious reasons for considering that they have committed one of those crimes, right? So that's the interesting dynamic between inclusion and exclusion, right? Between the provision that speaks to who gets refugee status and a provision that speaks to who is denied refugee status or ought to be denied refugee status, right? So those are some general comments. So I want to talk about this distinction between exclusion and expulsion. So let's assume the person, not in Evitar's example, the person was granted refugee status, and it's only later that whilst in the state of asylum, they commit a serious crime. Let's again say they have committed rape, or they have robbed a bank, or they were involved in serious drug offenses. Um, the state then is not obliged to let that person necessarily remain in its territory. There are certain circumstances where a state is allowed to expel a refugee that is lawfully in its territory if there are grounds of national security or public order that require it. There are two problems, of course, with the application of expulsion. The first is that it is still subject to reforma, right? So, because you can't have one provision of the convention contradict the other. So that person is still a refugee. So you cannot expel them back to their country of origin or to anywhere where they would face persecution. So you would need to expel them somewhere else. Um, or to another country of which they're not nationals, right? Because if they were a national of another country, then you wouldn't give them refugee status in the first instance. You would say they have to go to that state and get protection. So the likelihood that Article 32 would apply is very low, because the scenario you have in mind is someone who's committed a serious crime in your territory. You don't want them to stay. You can't send them back to the country that has to accept them back, which is their country of origin, because they are refugees. So you would ask a third country, someone else, to take in a criminal. Um, Very unlikely to happen. But the fundamental scenario, I mean, arguably, the sort of scenario that Donald Trump is trying to put in place with El Salvador, and some of the people, supposedly people who committed offenses in the United States, he wants to expel. He can't send them to Venezuela, so he wants to send them to El Salvador. So maybe that type of scenario. But the important thing for our purposes, for today's purposes of our discussion, is that Article 32, so expulsion happens having previously granted somebody refugee status. So, having granted the refugee status presupposes that when you were assessing their application, you decided not to apply Article 1F. So it's different than exclusion in the sense that these are not people who were denied refugee status. These are, by definition, people who were granted refugee status, and then at a certain point did something in the country of asylum that merited, in the eyes of the country of asylum, their expulsion, right? So expulsion is very different than exclusion, and it again relates in part to Evita's question or point. Expulsion is what you do in order to protect the country of refuge um, um, from the risk that the person poses to it, and it relates to a present or a future threat that emanates from their behavior in that state. Exclusion denies them refugee status because they are deemed to be undeserving because of something they have done in the past, right? And prevents them from escaping justice for those crimes. So that really takes us to the objectives of this provision. So there are arguably three types of objectives that we can think about. The first is to protect the integrity and the peaceful nature of asylum, right? You don't want to make asylum a form of or a method of escaping justice, right? Or escaping criminal law enforcement when that criminal law enforcement is um, is merited, right? So if you have committed serious crime somewhere else, then it shouldn't be the case that refugee law would be your way of escaping those crimes. And as I said, the challenge is, which is the challenge we're going to come to, uh, in relation to Articles 1FB and 1FC, is that there is disagreement as to whether the activities certain individuals have undertaken amounts to a crime or not, right? As I said, I'm not going to use that example later, but obviously, if there's a country where homosexuality is or sodomy, as it's defined in those laws, is a serious crime, in the eyes of those countries, that would be a serious non-political crime. In the eyes of many states of asylum, that would be precisely the ground to grant people protection, right? So there's a serious in relation to certain crimes, not all crimes. I should hope something like rape doesn't fall into that category of contentious crime, but in relation to many crimes, the fact that different criminal justice systems define certain things as crimes and others don't makes a difference in the application of that provision. And terrorism, even if all countries would agree that terrorism is bad, they wouldn't agree that a specific act in a specific context necessarily amounts to terrorism because their view as to whether something is terrorism is largely shaped by who committed the crime against whom in what circumstances, right? So that's a real challenge. So the provision is intended to do a good thing. It's intended to ultimately, you would think, it's intended to avoid a situation where people flee the application of the law to them when the application of the law to them is justified. That isn't what asylum is supposed to do, but it is supposed to protect people who are fleeing persecution and not prosecution, right? Who are fleeing something which may translate to criminal prosecution, but is in effect persecution, right? Like in the example I've given around sexuality. Um, and
That
ultimately,
very
sorry, go ahead.
that is very interesting. It raises, I think, a very interesting question or dilemma. Say if someone is in some countries homosexual and is
Sure,
prosecuted for it,
sure.
but is also unrelated to it a murderer,
Right,
and he would get the death penalty there. And let's say he
sure,
wants to come to Anka, our country, and for the murder he committed, say it was a very serious murder, he would also get the death penalty. But
sure.
just for that, do we grant him asylum in the sense, or do we even grant him asylum then execute him, but make the point that he's executed just for murder and he's gets asylum from his country as a homosexual? Do we just leave him he be? Say you're a murderer, we don't want you, we don't care even if they
Mm,
don't care that you're a murderer and they all they prosecute you as a homosexual,
yeah.
kill you for that.
Yeah, so that's a great example. I'll tweak it a little bit just to make it not fall automatically into um, other human rights protections because at least in large parts of the world, the mere fact that you would be subjected to the death penalty would protect you from sending someone back to
Mm.
the
Yeah,
place.
that's what
Let's
you
but let's
know.
but
You
let's
can,
as I say, let's tweak it to the to life imprisonment, right?
yeah,
Um,
say,
and I think you raise precisely the question around the relevance of the application of proportionality to this provision, right? So I want to come to that in 2 minutes. So I'm not going to forget kind of you know responding to this, but I'll come to that because it's precisely there that this dilemma arises, right?
mm,
Um, so so just before I talk about proportionality, I want to talk about a contestation to this framework, right? That the framework saying that this is all about keeping undeserving people away. And Colin Harvey, in an article that he's written, he says the idea that certain refugees may be undeserving of refugee protection because of their past criminality is incompatible with a reading of the international law regime, refugee regime as a human rights regime. To some extent, that's a response to your point as well. I mean, he would say, I suspect, I mean, I haven't spoken to Harvey about this specific example. I know him, but I suspect what he would say is that um, even if a person has committed murder, let's assume they've been tried for that, or that you could try them if you have the evidence to convict them, right? The whole framework of Article 1F is challenging because you're basing your assessment on something that people did somewhere else where you are not undertaking, a criminal justice process in its full sense. You're not conducting a trial. At this point, at the point at which you have to decide whether to exclude them, you're doing it based on evidence from elsewhere, which may or may not be a country that has proper fair trial provisions, etc. So that's a overarching challenge with this provision, right? So you're doing it based on evidence that may or may not be valid, right? But let's assume that person has indeed committed a murder. Harvey would say it's still the case that if they're being persecuted for their homosexuality, if that is a protected ground, then you shouldn't use exclusion as a way of essentially exposing them to that type of harm. They should be punished for the murder, but they shouldn't be, as you were, doubly punished, also for something for which they shouldn't be punished, right? By sending them back. That might be his response. That's a wrong reading, in his view, of the Refugee Convention to think about deserving and undeserving people if one is to apply a human rights framework, right? Which is a question, right? So, as I said, the question whether refugee
But
convention.
isn't it interesting in this sense that you might get it pose a practical problem because if I say live in Iran,
Yes,
um, and I've committed a serious injury or something, and I don't want to be prosecuted there, the prison over there, so I go to England or Germany, say I'm homosexual,
sure,
and now I'm going out of the closet right now in this country.
sure.
And if you bring me the back, they prosecute me. So even you can punish me for the injury. I don't care to sit even 10 years here, but I don't want to go there. Then
Sure, sure, but that's but
a
that
lot of
are but
people
that
may do it, take advantage for it.
but
Criminals.
many people would argue that that's I mean, again, as I say, there's a normative debate to be had here. Many people would argue that that's a desirable outcome. So the desirable outcome is that the person would still
Yeah.
be
No,
accountable
no.
for their crime.
No. The point is they are not homosexual. They don't, not really. They just say it
Well, no,
to
but
get
that, but, that, but
out.
that's an entirely separate debate. But that's because if somebody doesn't have a valid ground for asylum, then the whole context in which Article 1F arises wouldn't arise, right? Because if they're not refugees, the only context of our assumption for the whole discussion today is that people otherwise are refugees, right? So they do have a well-founded fear of persecution on your assessment, and it's despite that well-founded fear of persecution that you are sending them back because of something that they've done. That's our starting point. So the question. So you have to for your example to work, you have to work on the assumption that they are indeed refugees in the sense that if they didn't have that other crime, you would absolutely grant them refugee status. And it's a question of whether you should deny them refugee status because of that additional criminality, right? That's that's
No, yeah.
that's the narrow question, right?
Yeah, I guess, yeah, I just thought about it now, and I thought that it just a general bigger problem that the one we're talking about right now is how do you differ from false accusation of just
Yeah,
people who want to go out of countries to another and they just can say, oh, I'm homosexual, I'm against the regime, I'm dead or I'm dead, think that it's hard to prove, and they just do it because they
sure.
don't want to live in their country.
Sure. But that's as I said, I mean that's the burden of proof point, right? So it's not the case that anyone who just said that automatically gets protection, right? That's precisely the reason why you have credibility checks, why you do an asylum interview, why you rely on country of origin information, why the presumption is not a presumption that somebody is persecuted, but the initial presumption that someone who applies for asylum has to rebut is a presumption of protection. So this is a wider, they say this is not related to the effect of exclusion, right? It relates to the whole refugee framework. I mean, you're not wrong,
Yeah.
of course, to say that some people may try to abuse, but I mean, without getting into the wider debate, you can say this about any legal rule, right? People may try to abuse
Mm.
the benefit system. People may try to claim they're disabled when they're not disabled. I mean, that's a wider legal debate as to how societies calibrate the risk of false demands or requests or
Mm.
application with the need to protect those who are genuine applicants, right? I'm not dismissing your point as a practical point. I'm saying it doesn't arise specifically in relation to people who are excluded. It arises generally, right? So
Yeah.
it's a wider issue. Does that make sense?
Okay. Yeah. Thank you.
Cool. Okay. So let me continue then to like a few general points and then zoom in on proportionality, which I think comes back to the theme of your points of Yatar. So the first thing to say is that if one is to apply essentially a form of a criminal justice model to this question, then you need to go with that following criminal justice principles. And that means that an individual can only have committed a crime if the relevant conduct was considered criminal at the time of its commission, right? So you can't say that now you consider something to be an offense, but when the person has committed this act, it was not considered an offense. You can think about issues like offenses that have been created over the last few decades, say money laundering, right? So say someone has been involved in money laundering in the 1980s in something that 20 years later we would consider to be a crime. You can't, in the same way you couldn't convict them for an offense if something wasn't an offense when they've committed the act. You also can't exclude them on that basis because there is no retroactive application of criminal law, right? That's an overarching principle that is broadly accepted, right? So there might be jurisdictions which don't take that view, but the correct application of the Refugee Convention is one that takes into account this standard as a benchmark. And similarly, in the same way that in criminal law, if there's vagueness as to whether something is or isn't an offense, a particular act is or isn't an offense, um, any vagueness or lack of clarity works in favor of the accused. That same principle applies here, right? So if you're not sure whether what they've done is really reaches the threshold of an offense, then you shouldn't exclude them on that basis. The other thing is, in some instances, you might find the facts that relate to exclusion only after you've granted somebody refugee status. I mean, this is very possible, particularly in context of conflict, right? So you can imagine somebody from Syria who would have gotten refugee status in a European country, and then you would find that they were involved in war crimes, right? In your investigation. Entirely possible, probably has happened. In those circumstances, you've already granted somebody refugee status, so you can't now exclude them. What you can do is you can cancel it in the same way that you would cancel a visa that somebody got based on the fact that they provided false information for obtaining that visa, right? Immigration authorities do that all the time globally, right? And the key thing, and this is where we kind of segue into this proportionality question, is that you may exclude somebody from refugee status, but they would still be protected by virtue of other international instruments, right? And a classic example to go back to your example of Yatar is that if somebody say comes to the European Union and they are in the circumstances that you've described and they would be subject to the death penalty for an offense that they've committed for which they should otherwise be excluded, they would be protected from return just on the basis of them being subject to the death penalty. Um, and that in turn may make it more plausible to exclude them from refugee status because they would still have other forms of protection. So this is where proportionality comes into the assessment. The proportionality essentially takes into account two things. It takes into account the degree and likelihood of the persecution that is feared and the seriousness of the acts that are committed. That's the first thing it takes into account. The second thing it takes into account is that if a country were to exclude somebody from refugee protection, would they still be protected under other mechanisms? In other words, does the fact that they will not enjoy the label of a refugee and the rights that come with refugee status that may be better, maybe more protective, maybe more elaborate than the rights that attach to other temporary protection statuses. Um, if there is an alternative, then you are more likely on balance to exclude them. So even in your example, Vieta, if say somebody would be subject not to the death penalty, as I say, but would be subject to life imprisonment, but the conditions in prison, etc., you would deem to be ones that are inhuman or degrading, right? So you would still not return that person under human rights law to the country. But the reason they'd be subject, as you say, to the death to life imprisonment was that they committed murder, right? And you think that that sort of person should not be getting refugee status, even if they have valid protection claims based on their sexual orientation. The fact that you know they're not going to be returnable because of human rights obligations makes it more likely under UNHCR's assessment that you would exclude them from refugee status because there's a fallback position, there's a safety net of protection under other instruments. Conversely, if there is nothing else that would protect them, if the consequences of you excluding them from status is that they will be sent back and they will then suffer persecution, that's our assumption, right? That they are refugees, meaning that they have a well-funded fear of persecution. Then what you might need to engage in is that first point that you see on the slide. You have to weigh in ultimately a very difficult kind of balancing act. You have to weigh in what they've done, and you have to weigh in how terrible the persecution they'd suffer would be. So let's take like a hypothetical example. As you say, somebody has committed murder, and they come from a country not where there is the death penalty or life imprisonment for somebody who's gay, but where there aren't sufficient protections from discrimination, right? They can be sent to, they can be sacked from their workplace. They can be harassed by people and they might not be fully protected by the police, but there's no criminalization. Let's say those are the two balancing. It might be that a state would say, we don't want to welcome in a murderer into our territory. And unfortunately, that means we're going to send them back, even though they'd be subject to certain forms of persecution that are not as severe as the sort of crime they've committed, right? That's supposedly the balancing act that would be engaged in. It's a very difficult one to engage in, of course, because you're saying not only, as we've discussed, I think either yesterday or the day before, does persecution have to reach a certain threshold? So not every discrimination or not every harm is persecution. You're also essentially saying there are different gradations of persecution. There is serious persecution for which you should always be protected. And there is like a more mundane form of persecution to which we are willing to subject you by sending you back, right? It's a very difficult kind of principle to apply, and ultimately, the more likely scenario is that states would try to find other means of allowing that person to stay through human rights or other forms of protection rather than give them refugee status or send them back, right? Which are those two polar opposites, right? That of the refugee regime as mandated by Article 1F, right?
Wait, but in this situation, they are still, so you give them some status, but you still put them in jail for the
Potentially.
crimes?
Well,
What?
well, it depends, right? So if the crime, remember that the fact that somebody has committed a crime, in order for you to imprison them, right? So you all you need under Article 1F is serious reasons to consider that they have committed a crime. But in order to actually put them in jail, in your country, you would need to undertake a criminal justice process. You might choose to do that, right? If they haven't undergone that process before. But the scenario I'm describing is more likely to occur in a situation where somebody has already served their sentence. So imagine
Mm,
somebody who was convicted of armed robbery, sat 10 years in jail. Now they flee to your country and they say, I'm persecuted on grounds of my religion, say. And you now say, well, you're a serious criminal. We have evidence you've sat in jail for 10 years. We don't want people of your kind in our country. Um, if you were now to send them back to their country of origin, they would suffer persecution, right? So that's the balancing act that you're engaged in. I mean, it's often would be a situation where the person has already paid the price for, as you were, the price in quote unquote for the crime that they've committed. If they haven't, if you only have suspicion that they've committed a crime, for you to actually put them in jail you would need to follow the procedures for doing so. You couldn't just automatically, in the same way you couldn't imprison anyone else, right? So unless you follow a criminal justice process, right? So I think we need to be careful about that, right? So that's an overarching again principle of criminal justice. So to go back to this point about the standard of proof, um, the use of the language serious reasons suggests that we're not talking a criminal law standard, right? So we're not talking a standard of beyond reasonable doubt. That's not the standard you apply at the state because you don't have the means usually to assess at the time you're making this decision um, whether somebody has committed that crime beyond a reasonable doubt. So in certain instances, that may be the case, right? So there might be instances where, as I say, if somebody has sat in jail somewhere else for that crime, you have access to the court records, and you are able to see that they sat in jail, perhaps justifiably in your assessment. Then, then the standard of proof is very easily met. But that's not always the case, right? It may be that they haven't yet served the sentence. It may be that even if they did, it's in a country where you're not 100% persuaded the criminal justice system is one you can trust, right? So you're not, that's why there isn't a demand of that standard of proof meeting a determination of guilt but rather, sorry, meeting a beyond a reasonable doubt, but rather it needs to be sufficiently high to ensure refugees are not erroneously excluded, right? So you can't have just a balance of probabilities. You need to be persuaded that is the case because the consequences are very severe, right? So the consequences are potentially you're sending somebody back to being persecuted for a ground that you believe they should otherwise be protected from, right? So that's again, that's the whole premise of the application of this provision is that if there wasn't that other crime that they have committed, you would grant them protection, right? So in order to deny them protection and send them back, you need to be you need to have quite serious evidence to justify that sort of outcome. So with that in mind, let's go into the specific provisions. And as I said, the easier one of the three is Article 1F A, which says somebody has committed a crime against peace, a war crime, or a crime against humanity as defined in the international instruments. Now, when the convention was drafted, actually the only international instrument that was relevant to one of those three types of crime was the Geneva Conventions, which talk about serious breaches of those conventions amounting to war crimes. Today, we have those war crimes being defined as war crimes in the statute of the International Criminal Court. We also have crime against humanity defined in the statute of the International Criminal Court. And we have crimes against peace in their modern terminology, which is aggression, also defined in the statute of the International Criminal Court. So um, today, this provision is more easily applicable in the sense that we know what the crimes are, right? So unlike Article 1FB, which we will come to, with Article 1FA, the the specific crimes that apply to this provision are legally defined in international law, right? So there's no doubt as to what those crimes are. There's also increasingly jurisprudence as to how one should interpret those crimes, right? So not on aggression, not on crimes against peace, because the last time somebody was tried for crimes against peace was the Nuremberg trials, and that was before these instruments. So this is a new addition to the ICC statute from 2018, and no one has yet been convicted on the basis of crimes against peace or crime of aggression. But certainly for war crimes and crimes against humanity, we've had various convictions in different international tribunals, in the Special Tribunal for Yugoslavia, for the former Yugoslavia, for Rwanda, for different hybrid courts like Cambodia, and of course the International Criminal Court itself. So there is also jurisprudence. So in a way, this is an easier provision to apply, and the people to which it is likely to apply depend on the type of offense, right? So it's considered to be unlikely that you would apply the provision around crimes against peace to somebody who is a low-level soldier or political apparatus in the state. The assumption is that you would apply it to a leader, right? So someone like Vladimir Putin for invading Ukraine, right, would be a classic type of crime of aggression, right? Or at least alleged crime of aggression. Um, International humanitarian law is different, right? Because um, you might have a much wider kind of involvement in such crimes by units, by commanders. So there might be many people who are involved in commission of crimes that are defined as war crimes. The practice of courts, of international courts, has been to try only relatively high level people rather than to put on trial thousands or tens of thousands of people. But this is different, right? Because here you're not choosing whether to try someone, you're deciding whether to exclude someone based on information that you've got. So the person you have in front of you might have been relatively low level in Islamic State in Syria, but they still have murdered 10 civilians or something. You might say that's sufficient for me on the basis of my evidence to not give them refugee status, right? So you don't need them to be the commander of the whole region of Islamic State. You might say that they themselves have lost their justification, as you were, or desert, to use the other kind of perception, to be getting refugee status. And similarly for crimes against humanity, right? So they also, if we look back to cases like Rwanda, uh, the in the course of the genocide in Rwanda, there were many crimes against humanities or crimes against humanities that were committed by ordinary Rwandans, and they would meet this definition, right? Partly because crimes against humanity is something that can be committed both during peacetime and during a conflict, right? So you don't need a threshold of an armed conflict to apply in the same way war crimes require it. They can happen in circumstances where there isn't a formal armed conflict and there are still crimes against humanity being committed. Right. So Article 1FA, I don't want to spend too long on it because I think is actually relatively easy to understand in terms of scope, also less controversial in the sense that because these are international crimes, they should I say, rather than necessarily are, um, uncontroversial in terms of the need for them to apply, right? So those are crimes that have been agreed by the international community. I mean, granted, not every country is a signatory to the ICC statute, but every country is a party to the Geneva Conventions. So all countries in the world have signed the Geneva Conventions of 1949, and those conventions define serious breaches of those conventions as war crimes. So those shouldn't be contentious because all countries have agreed those are crimes. And in respect to the other crimes, the majority of the world's population, the majority of the world's countries have signed up to the ICC statute. And so at the very least, it's a starting point, certainly for very many countries that have signed the Refugee Convention as well, to say this is our benchmark and this is what the provision requires. So that's the easier, as I say, of the three. The harder one is really Article 1FB. So I want to zoom in on the specific components of this provision. So what this provision requires you is to have committed a serious non-political crime, right? So there are two components here. The crime has to be serious and it has to be deemed to be non-political, right? So if a crime is serious and political, it's not excludable under Article 1FB. If the crime is non-political, but is quite mundane and basic, I don't know, a traffic offense that is deemed under domestic law to be a criminal offense, right? That also wouldn't fall into this provision, right? So the crime has to be serious and has to be non-political. And of course, it had to have been committed outside the country of refuge and before admission to that country, right? So it had to have already been committed, which is the same case for Article 1FA and 1FC. So what do we think about that provision, right? How do we determine whether a particular offense is sufficiently serious within the meaning of this provision? Do we apply international standards or do we apply local standards? Ultimately, we want to think about what non-political means as well. Uh, Ordinarily, at least in the literature, people suggest that what you think about as non-political is when the motivations that have driven you to commit this crime were predominantly non-political, right? For instance, wanting to having been promised a large sum of money in order to commit this crime, or obtaining great fame and support from certain groups, rather than the specific political goal of your activity. Um, and of course, to kind of reiterate that point, if you commit a serious non-political crime in the country of refuge, then exclusion doesn't apply, right? By this stage, you might be subject to expulsion under Article 32, but you can't be at that stage excluded. So it had to have been committed prior to that. So I'm gonna kind of suggest to you some criteria that arise from the literature to what you would consider to make a crime, excuse me, sufficiently serious. You look at the nature of the act, you look at the harm that it inflicted in actuality. For instance, if there was a grave bodily harm to someone, that would be often an indication this crime is serious. The procedure that is used to prosecute it. Do we ordinarily use criminal law or do we use administrative law, for instance, for these sorts of crimes? what is the nature of the penalty? So, is someone likely to go to jail for a long period of time? Is it only a fine or some other form of compensation? And indeed, whether most jurisdictions consider it a serious crime, right? So, what states might do, and often do, is they consider only whether they deem that action to be a serious crime. But that arguably is problematic if you're thinking about the application of an international framework, because you might have peculiar criminal justice laws, and you might want to see whether you are an outlier or whether actually the position in your country is quite representative. So, so those are some criteria for a
But
serious crime. Sorry, go ahead.
yeah, no, but why? If there's something that I consider very serious, say
Mhm.
I'm more advanced, say I'm a country that a subject that close to my heart, say it's animal rights. I decided I'm a country that decided that right now that people who kill, so if you kill a dog, um, just unjustifiably, no self-defense, then you go to 15 years in prison. I think there are
Sure.
many people who will agree with that, but most country will give it what, 4 or 5 year top. So I consider it much more serious crime, but I don't think I should. But I think it is. We would say that the country has definitely a legitimate reason
Hmm.
to consider it, even if it's peculiar.
Yeah. So you raise an interesting challenge, right? An important challenge. I mean, I think the tension here is the following. I mean, many people would agree with you on this, right? But I think the tension is the following. If you think about the Refugee Convention as ideally, right, even if not in reality because of the self-application across different states, if it's ideally supposed to provide a person's fleeing persecution the same outcome of their asylum application, irrespective of where they ended up, because where you end up is a luck of the draw, right? Is a question of is a question of chance. It's a question of where you were able to travel, rather than a substantive criterion. Then to have differentiation in the assessment of your situation, depending on the individual state, undermine that ideal. Now, you might say, which is fair enough, I accept that. I accept that there might be a degree of divergence, but I'm not willing to give someone who has committed, in my view, something that is a serious crime the status of a refugee. I think that that would be there would be a contradiction in terms of how I understand activities. So I take your point. I think that I should say animal rights are also close to my heart because I'm vegan. But
Yeah, me too.
so on that ground,
Yeah,
but it's I think that's actually a good example of a case where I think you're absolutely right that in some countries crimes related to animal abuse and otherwise are likely to be seen as serious, whereas in most jurisdiction, I would say sadly they're not, and so that is a good manifestation of this example, right? I think,
yeah. I mean,
yeah,
you,
go ahead.
you can also say that there are limits. I mean, we try to make it neutral to the
Mm,
country. Someone comes in as much as we can, but there are just limits to this, to the possibility
yeah.
if you want to
So
keep other values as well.
sure. So I think to some extent this is where proportionality also comes into effect, right? So it also depends, or at least to me, it makes sense to subject um, whatever assessment you make of what the person has done, you subject that to an assessment of what they'd be subject to if they were to be returned, right? So what is the likelihood of that happening? So the fact that you have to balance those two makes that consideration relevant. But you are, I think, as I say, I think it's a fair challenge to say that um, in certain circumstances, states might say, I don't care whether other countries consider it to be a crime. If in our eyes it's a crime, that's sufficient, and vice versa, of course. So the same applies. So there might be a case where most countries consider something to be a crime. If you don't consider it to be a crime, you're very unlikely to use that as a basis for exclusion for the same logical reason, right? If you don't think that what that person did was wrong, then you're not gonna realistically, you're not going to be basing your decision on standards that apply in other countries rather than yours. So I think that manifests the tension, right, as I say, which I think exists at the heart of the Refugee Convention between universality and particularity, right, between an attempt to have universalized, harmonized standards and the fact that there are actually different value systems and different perceptions of what is and isn't appropriate conduct, right? Which in extreme form translates to what is or isn't a crime, which then affects the way those states assess individual cases. So it was a good challenge. So thank you. Um, and so on the non-political side, the UNHCR position, as I said, is that if there are other motivations, then if they're predominant, that may put in question whether this is a political crime or not. And remember, if it's not a political, sorry, if it is a political crime, even if it's very serious, it's not excludable under the Refugee Convention. So in certain instances, you can think about serious crimes. Um, that are political. I don't know, murdering a prime minister, right? That is a very serious crime, arguably a political crime, right? So that might not be a crime that would be excludable in the eyes of the Refugee Convention. There might be other reasons to exclude, but not under Article 1 FB. So instances where there's no clear link between the crime and the political objective. So there might be that a person is a political activist, that they are trying to achieve some political change, but the specific crime they chose seems to have no clear link to that objective, right? So that can be the case, right? It can't be that you've got somebody who's a political activist and on the side they also commit a serious other crime. It's entirely plausible, or that the act in question, and this is the more questionable criterion, is disproportionate to the alleged political objective. So let's say you do have a political objective, but the type of crime you commit is deemed to be disproportionate. Now, that may be a way of getting around this notion of non-political crime. So some people might say murder should be in all circumstances prohibited. And so even if you're doing it for political motivations, we shouldn't deem murder to ever be political, right? Some people might argue that. I'm actually not persuaded. I'm not sure that's the case. I'm not sure about this standard for non-political crimes. That's a UNHCR standard. I think it's debatable, but that might be an argument that people would make. So with that in mind, I want to zoom in on the Snowden case and kind of see what your thoughts are on it. So Snowden was a U.S. sorry, National Security Agency contractor, and his project was ultimately having worked for the National Security Agency. He was revealing by leaking information to newspapers, primarily The Guardian, the extent of the U.S. security services surveillance operations. And he leaked documents. I mean, there's an argument that he leaked them in a way that had limited effect on national security, but that's a factual question that would be determined if and when he would be tried, right? And not the heart of our question. It's very clear that he leaked documents. It's very clear that he did so as a employee who was required not to leak documents, of course. And the documents revealed that the US was surveilling people in the United States, but also outside, including world leaders, in ways that, of course, are legally questionable, if not outright illegal under international law as well, breaching people's right to privacy, etc. And so the US, when this was discovered, when he was leaking the stuff, there were charges against him placed by the US Department of Justice on counts of violating the Espionage Act and also theft of government property because he had documents that he essentially taken away and not returned. But the main, actually, quite serious offense was under the Espionage Act itself, which dates back to 1917 in the US case, leading ultimately Snowden. The time this was issued, he was already, I think, in Hong Kong, and then he ultimately ended up in Russia. So we can think about it through the prism of asylum and through the prism of exclusion. So through the prism of asylum, you can say, firstly, um, this is not a case of a non-political crime, right? The crime is very clearly political. The motivation, as far as we know, he didn't really receive um, a big monetary compensation from the newspapers he's leaked the information to. He had a secure, good job in the United States. He lost his American citizenship. He lost his job, of course. He's a fugitive, right? So it's hard to see what the non-political gain here as well, and the sort of things that Snowden has exposed are ultimately political in nature, in the sense that they raise questions as to what are the limits of surveillance. Should states be allowed ultimately to spy on other states? We know they all do, but is that something that we want our state to be doing in other states? What are the human rights implications? Those are debates, right? People will fall on different sides of those debates, but they're legitimate debates that he wanted to prompt by the leaking of the information. And the argument would be on the asylum side that in the United States he could not get a fair trial because he's deemed to be a traitor, that the sort of punishment that might be meted on him, even if not the death penalty, would be very severe, potentially life imprisonment, and that he might not even be imprisoned in conditions that we would deem to be meeting humane standards, because he might be in solitary confinement and in other conditions. And so, on all these grounds, even if we think that what he's done is a crime, we would think it's a political crime to which you would be subjected to disproportionate or particularly harsh punishment. Right? That would be one side of the equation. The other side of the equation would be to say he should be excluded because the crime is serious. There's no doubt. Virtually no country, even taking Aviatar's challenge, virtually no country would accept that somebody working for its security services can leak classified information. It's very clear that that's prohibited under domestic law virtually everywhere. It's not possible for security services to operate unless there is a prohibition of that nature, and all countries always deem the leaking of classified information as very serious. And the question whether it's non-political or political is debatable, right? So you could say, if you took an exclusion framework, you could say ultimately you can say everything is political, but he did get fame and everybody remembered his name. He did get some financial compensation for doing this. And his motivation may have been complex and varied. There might have also been political motivation, but there might have been others. And ultimately, for the United States to prosecute him for something that is a crime in other countries as well, and indeed a serious crime, would not be itself persecution, would be the United States defending its national interests through its criminal justice system. And if there are specific concerns around the type of trial he would undergo, etc., then those are the concerns we need to address, but not the mere fact that he's being prosecuted. So those are the two sides of this debate. Does anyone have instinctive thoughts as to if they were a decision maker. Let's say Snowden didn't end up in Russia, which of course hasn't really undertaken a proper asylum assessment. Let's say it ended up in Israel, right, or in or in the United Kingdom, and there is a request from the United States to extradite him, and he wants to get asylum, right? Of course, if he were to be excluded from status, unless there are other human rights grounds, you would then extradite him based on an extradition agreement. If you were to give them refugee status, then of course you wouldn't extradite them, right? So, what are there instinctive thoughts on how you would settle a case like this? There's no right answer to this question, right? Because I mean, we don't know. We only know a set of facts that I've described, right? Um, there might be other components, but on the set of facts that I've described.
Mm, I I think that you know I don't have a clear answer. I don't have a
Mhm,
clear answer, but I do feel that if they do prosecute, if they do give, if some country does give an asylum
mhm.
to Snowden, they do also need to have some repercussion against the United States, the state, or any other state for that matter, because then there would be illogic in saying, well, we grant him asylum, but we don't proceed in any diplomatic or even military action against the United States of some sort. We just let it go, even though we do agree that they committed a serious crime.
But we don't necessarily
So
know. I
if,
mean, it's not obvious from the example I've given that the US surveillance applied to people in your country, right? In the country that makes the asylum decision. Let's say
mm,
you're a country, your country, the US has no interest in. It's too small and insignificant in the US's eyes to care about, right? So let's not add that component of the grievance the state itself has. Let's just assume the state cares about the idea that we shouldn't have other countries spying, etc., but they don't have a specific grievance. It still raises the question, right? It's still a difficult thing, and it's also, I think the fact that you're not sure, and the fact other people, I'll give a chance to other people to come in if they want. Unsure, I think is reflective of this being a difficult case. I think that's why I'm bringing this as a test case, right? Because um, I think it is an easy case in terms of accepting that leaking classified information is a serious crime, right? So I think it'd be very difficult to make the case that it shouldn't be a serious crime, but whether it's a political crime, right, is really debatable, right? And it affects. That's why the way Article 1FB was drafted was very, very specific, right? It used the word political non-political deliberately, right? It's not a some kind of some drafting mistake, right? So if there are no other contributions, then I think let's talk about one FC finally, and then we can break for have a substantive break. So one FC is about committing acts that are contrary to the purposes and principle of the UN. And as I said, the language here that's been used has been guilty. So that presupposes some sort of a process having already taken place where the person was found to be guilty. It's not always obvious what this would translate to in practice. It may arise, for instance, in cases where people are so-called refugees so plus, right? Where somebody was tried in your own country, right, as having committed these sort of crime, and now they apply for asylum because they want to stay in the country, right? That can be a scenario where this happens because this provision doesn't say that the crime had to have been committed outside the country of asylum, right? So it might be that you were tried in the country of asylum even. At that stage, of course, you would have been granted refugee status. So if you had come as a refugee, but you might have come on other grounds, right? You might have come as a student, or you might have come as a tourist, or what have you. So this provision, the context in which this provision applies temporarily is more complicated, but the crime had to have been committed already, and the person must have already been found guilty of that crime. I'm not going to go through the list. You'll have them on the slide because there's really no point in going through the whole list of Article 1 of the UN Charter of the purposes of the UN and Article 2 of the UN Charter, the purposes, the principle of the UN. They're all very lofty and nice and cozy and things that we all states presumably want to protect, right? And so the question is, what are acts against the principles and purposes of the UN? What amounts to those sorts of crimes? Um, there's a typo there. It's so UNHCR again takes the view that these are crimes that are capable of affecting international peace and security and peaceful relations between states, as well as serious and sustained violations of human rights. And they say this is a very vague provision, so we need to interpret it narrowly and with caution, right? So again, this is a general statement about Article 1F more generally, but it's specifically true, unlike with something like war crimes, where we've got a very clear definition in international law. Here, it's very difficult to say what is an act that undermine friendly relations between nations, for instance. Well, what does that amount to? So UNHCR takes the view that many of the acts in this provision may only be committed by people who act on behalf of states or quasi-states because the principle and purpose of the UN are intended to be a guide for states in their interrelations. But at least UNHCR's view is that acts that are properly considered to be of a terrorist nature, and because of their gravity and nature, they're capable of affecting international peace and security or friendly relations between states, may also fall within the scope of this exclusion, provided it is established the relevant individuals has individual responsibility. So, of course, an overarching principle around all of Article 1F is again, like in criminal law, you can't have just general guilt by association, just being, I don't know, a member of a group that has been prescribed as a terrorist group. You needed to have actually committed a specific act that has this effect of undermining one of those principles of the UN. And so the main question, the main kind of normative question is, are all actions that are defining terrorism in domestic law automatically contrary to purposes and principles of the UN? And does the international condemnation of terrorism, but the absence of an agreed international definition, means that states have discretion, a bit like what Evyatar was suggesting in relation to general criminal law, to interpret these provisions as they wish, or are we looking for some sort of a autonomous true meaning that is tied to international peace and security? And there was an interesting case in the UK Supreme Court called El Siri a few years ago that took the following view. It said the essence of terrorism is the commission, organization, incitement, or threats of serious acts of violence against persons or property for the purposes of intimidating a population or compelling a government or international organization to act or not to act in a particular way. This, it seems to us, very likely that inducing terrorism in the civilian population or putting such extreme pressures on the government will have the international repercussions referred to by UNHCR. In other words, they say if we deem something to be terrorism, then it meets Article 1FC, and then ultimately we end up in the same territory of proportionality that we were just talking about in relation to 1FB. Um, what are the implications if, say, somebody was involved at a low level in some act that fell under the wider umbrella of terrorism under domestic law. Let's say that act happened 10 years ago. Would we today deny them protection, send them back to be persecuted? Right? Again, the type of challenge that arises. So this is what I wanted to say, I think, about Article 1F. Um, just want to see if there are any final questions on it. If no one has questions, and we've gone for quite a long time, I think we will break now. I suggest for about 25 minutes. So we come back at 20 past the hour. So in your case, 20 past 4. And then we'll spend the rest of the time today looking at Article 1D, which I'm sure, as I say, will prompt considerable discussion. So I will pause the recording and see you in 25. Resume the recording. With this in mind, we're now going to move to, as I say, one I think of the most interesting and challenging bits of refugee law generally, of this course in particular, which is our discussion of Article 1D of the Refugee Convention. Obviously, in some ways, made even more interesting and challenging in recent years. And yeah, I think let's just jump into it. So I will share my slides again. Hopefully everyone can see them. So like I did in the first half, I want to outline, the different headings under which I'm going to consider issues. As I said, if we finish a little bit early, we'll finish a little bit early. There's no point in moving substantively into a new topic. I anticipate we might need the times that we have allocated, but we shall see. Um, so I'm going to start by looking at the structure, sorry, or the objectives of this provision, this very specific provision with its historical context. Um, I then want to look at different elements of its application, and in particular at the interpretive questions that arise in relation to the exclusion bit of this clause, Article 1D1, and to the exclusion bit, sorry, to the inclusion bit of this clause. I'm going to get this confused because it is confusing under Article 1D2. Ultimately, I've suggested to you that most of the refugee law community considers this clause to be a contingent inclusion clause, and the reason for this is that anyone who gets excluded under Article 1D1 might potentially, if they were to come to a convention signatory country, in significant circumstances, including for many Palestine refugees, circumstances that arguably were present in the last few years, could automatically, ipso facto, so by that fact, become convention refugees based on the language of Article 1D2. And there's a certain irony which I would come back to as we discuss this provision, that the more people are excluded by Article 1D1, that is, the more people meet the criteria for exclusion, the more people are potentially eligible for inclusion if the conditions are met under Article 1D2. And that's a tension that exists in terms of how we perceive of this provision, because I said before the break, we think about Article 1F about exclusion because it's very clearly an exclusion clause. We want to interpret its provision narrowly, restrictively, in a way that ensures that only people who really should be excluded from status are excluded from status. Here, the situation is more complicated because you you want to exclude people who get protection elsewhere, but the consequence of this might be, as I say, an increase in the number of people who other countries might have to include. This sounds probably very confusing and unclear at the moment. Hopefully, as I proceed through, you will become much clearer. So let's start with the text of the convention. I'm just going to present at the moment the full text, and then we will go through the history, as I say, in the context, and we will return to the specific elements. I just want you to already, as you read this, think about the elements that I've highlighted in yellow, because those will be the center of our analysis later. So what this provision starts with is like Article 1F. This is why some people would classify it as an exclusion clause. It starts by saying this convention shall not apply. This convention shall not apply to persons who are at present receiving from organs or agencies of the United Nations other than UNHCR, so receiving from a different United Nations agency, protection or assistance. So the first thing to notice about this is, of course, it says nothing about Palestinians specifically, and it doesn't say anything specific about UNRWA. The reality, as I will come to discuss in a few minutes, is that at the time this article was drafted, which is 1951, as you know, there was one agency that existed that was providing protection or assistance to a group of refugees, and that was UNRWA. And no other UN agencies existed at that time, and no other UN agency to address this specific task, as it were, on a UN level, has been established since. And so, even though the provision on its face is not a provision about Palestinians specifically, but about anyone who would get protection from a different agency, in effect, it's a provision that found its way to become a provision related specifically to Palestine refugees. So that's the first, I think, kind of contextual understanding of this provision. And it's very clear that when it was drafted, this is the group of people that the drafters had in mind. That is abundantly clear from reading the preparatory work. The second thing to say is the second part of the provision says about that protection or assistance, and this is why it's a contingent inclusion clause, when such protection or assistance has ceased for any reason in circumstances, that is, without the position of such persons being definitively settled in accordance with the relevant resolutions adopted by the General Assembly of the UN. This is, of course, code very directly to specifically Resolution 194 of the General Assembly, which, as I'm sure you will know, is the resolution that says that refugees wishing to return to their homes and live in peace with their neighbors shall be permitted to do so at the earliest possible time. That is the provision that refers to the so-called right of return of Palestine refugees to their former places of residence in what has become Israel after the War of Independence or the 1948 war, right? And what this provision is saying is if ultimately protection or assistance no longer exists, it uses the term for any reason. We will come later to see for any reason doesn't actually mean for any reason, um, for interesting interpretive reasons. Um, so when protection or assistance has ceased for a relevant reason, we'll put it in those terms, without there having been a resolution of the Palestine refugee issue, that's the translation of the middle part of this provision, which there hasn't been, as we know, then these persons shall ipso facto, which is Latin for by that fact, be entitled to the benefits of the convention, which means by that fact, they become automatically convention refugees without having to meet the definition under Article 182, which we've spent considerable time looking at. There are some exceptions to this, which I will address later, but that is the fundamental basis. So the fundamental basis, if you think about it, is there's a group of people who were or are eligible to, that's the debate we'll come to, receiving protection or assistance from another UN agency that is not UNHCR, in this context, UNRWA. That protection or assistance no longer exists for them for reasons that we will uncover later. If that is the case, given the overall Palestine refugee problem hasn't been resolved, if they find themselves in a convention signatory state, say the United Kingdom, they would be automatically convention refugees in that state, unless certain qualifications apply. That's the overall framework of the provision, and I will go through step by step each of the elements of this provision as we proceed. But before we do that, it's important to understand why this provision, why this agency came into being in the first instance, and indeed um, who is eligible before we get to the interpretive question of what it means to be receiving protection or assistance from UNRWA, who is eligible for that protection or assistance. So let's start doing it in stages. So the overall objectives of this provision, according to UNHCR, which of course is the agency that otherwise generally protects refugees, is to ensure that quote unquote Palestine refugees continue to receive protection and associated rights until their position has been settled in accordance with UN General Assembly resolutions, and at the same time to avoid duplication and overlapping competencies. So it happens to be the case that even though the countries in which UNRWA operates, which we will come to a bit later, which are Lebanon, Syria, Jordan, the West Bank, including East Jerusalem um, and Gaza, with the exception of East Jerusalem, none of those other places are signatories to the Refugee Convention. But at the same time, UNHCR has presence in those countries and addresses refugee concerns, for instance, of a Syrian refugee who ended up in Jordan during the civil war, right? So there is a UNHCR office and it addresses its concern. And that has always been the case, right? That those countries have not signed on to the refugee convention, but have had refugees nonetheless. Lebanon, of course, has a very large number of Syrian refugees in addition to Palestinians. And so UNHCR was and is incredibly keen to ensure that the turf war doesn't happen, right? That it's very clear who has responsibility for which group of refugees, and that UNHCR does not have responsibility for Palestine refugees, at least not in those five countries, right? Or those five territories, rather. So that's the overall purpose of the provision. And now to the historical context. So the historical context is a resolution, a UN General Assembly resolution proposed by France, Turkey, and the US. Those were the countries that were party to the UN Conciliation Commission for Palestine, a body, a little known body that operated in 1948, um, as well as the United Kingdom. So they proposed a draft resolution, and the context was the fact that there were over 700,000 Palestinians who were displaced in 1948 to those territories. And I'm certainly not going to get into the narrative discussion of displacement versus expulsion versus encouragement, because it's not relevant for the application of this provision. The causes of displacement are not part of the definition, as you will see in a few minutes. I actually think for good reason, precisely because there are different narratives around what prompted displacement. So, as a matter of fact, people were displaced. There were 700,000 or so people displaced to those territories, and there was no sufficient provision for them by existing agencies. And so those countries said, hold on, unless we do something, those people will fall between the cracks. I mean, you might say those people would have become the responsibility of the countries in which they ended up, but that is something politically those countries at least did not want, and the countries that proposed the resolution did not want either. And so instead, they decided to establish a successor for what was a low scale agency, the UN Relief for Palestine Refugees, that has a broader mandate to provide humanitarian assistance and development, which goes beyond just an emergency operation. And so, UN General Assembly Resolution 194 spoke about the rights of refugees to return and about restitution. And UNRWA was established about a year later, right? So about a year after this right of return resolution, the UN, as its full name is, Relief and Works Agency for Palestine Refugees in the Near East, was established by a UN General Assembly resolution on a mandate that is not indefinite, but is fixed term and renewable. And each several years, given that it's a UN agency, that mandate gets renewed. And I believe the current renewal is until 2029, but it certainly is for several more years based on its current mandate in the eyes of the UN, which pertain to the different areas in which UNRWA is allowed to operate. So bizarrely enough, as you will see from the slide, it actually started operating before, but it operated without that resolution in place yet because there were needs already. But once the resolution was passed and proper funding and structures were put in place, in order for it to operate in the five areas that I described. Um, Ultimately, whereas initially was an agency that dealt with what we would deem to be emergency needs as the years progress, and I'm sure that's something that's quite well known in Israel, UNRWA's operations have expanded to the extent that they have become a mini state, as some would have called it, and some have in the literature, in the relevant spaces where they operate. So, of course, they cannot provide some key services the state provides. They can't issue um, national passports. They can't provide national security or even policing. They can't raise taxes. So they're fundamental functions of a state which they cannot function, which they cannot undertake, which means that they obviously are not a state and are not state substitute, but they provide lots of services in the spaces they operate, which if UNRWA did not exist or stopped operating tomorrow morning, you would expect the relevant state to be providing in particularly areas of food, of health, of shelter, of clothing, and education, which in large sense has become the centerpiece of much of its operations. Nearly one third of Palestine refugees, as the label is used, live in recognized Palestine refugee camps in the different areas. Many others don't, right? So many others live in big cities or in villages, but not in designated refugee camps. UNRWA finds it easier, of course, for its operations to operate in refugee camps. The political questions around the existence of refugee camps, including in places such as the West Bank, where there's both a refugee population and a native population, as you were, of those areas prior to 1948, is, of course, a very fraught political question, which I'm not, again, falls outside the scope of our analysis, but uh, of course, I appreciate is a question a lot of people have on their minds. And that's the definition that the UNRWA itself provides for what is a Palestine refugee camp. Um, and as the slide suggests, UNRWA also maintains schools, health center, etc., outside those recognized camps. So this takes me to the eligibility question, which is the first challenging question, right? So the eligibility here, and this is the important point, is eligibility to be registered with UNRWA in order, as a precursor, to be entitled to receive its services, essentially its protection or assistance. So without registration, you can't receive the services, and you would only be allowed to register if you are a refugee within the meaning of the definition. So you have to be someone whose normal place of residence was Palestine between the 1st of June 1946 and the 15th of May 1948, essentially having been ordinarily resident in British Mandate Palestine in the 2 years preceding the War of Independence or the 48 War, and who has lost both home and means of livelihood as a result of the conflict. Right. So the first thing to notice about this definition is that there's no blame assigning or element of persecution or element of attribution in this definition. It's not a definition about whether who's responsible for the fact that those persons have lost their home and means of livelihood. It's a factual question. Did they have a home in a place that has become Israel, or, by the way, a place in the West Bank or Gaza if they found themselves outside British Mandate Palestine and relocated from, say, the West Bank to Jordan, which has happened very rarely in 48, but did, and has happened more so in 67 in larger numbers, a few 100,000 people during the Six-Day War, which is why there was a tweaking of the definition to also apply to people who were displaced from the West Bank into Jordan, which is, of course, also a territory where UNRWA operates. So that's the initial category. These were the 700,000 people or so that the resolution referred to. But of course, many of those people are not alive anymore because this is 76 years ago. So UNRWA extends the provision of its services also to those who are born to male Palestinian refugees. So it follows what is nationality law in many Arab countries, used to be in many other countries as well, including many European countries. It used to be the case that nationality was passed through the father and not through mothers. Most countries that had that policy have changed that policy, but the region maintains broadly that policy, and UNRWA follows that policy. What that means practically is that if you have a Palestinian woman marrying a Jordanian man in Jordan, their children will not be Palestine refugees, but they will probably be Jordanian citizens because of a male Jordanian father, and vice versa. If the father is Palestinian, the mother is Jordanian, they're not going to be Jordanian, but they will be Palestinians, right? And that's why, again, one can debate the rights and wrongs of why UNRWA takes that position and maintains it. Um, but it's a position that is intended to avoid protection gaps in terms of that component of nationality and eligibility for protection in the areas where UNRWA practically operates, which are, as I said, Lebanon, Jordan, Syria, the West Bank, and Gaza. Now, implicit in what I've said, indeed I have explicitly said that as well, not all Palestinians are eligible for UNRWA's protection or assistance. In the West Bank, the majority of people who live in the West Bank are not because they were there, or rather their parents or grandparents were there in 1948. They haven't been displaced, then they're not eligible for UNRWA's protection, which means they're not excluded from protection under Article 1D1, and neither will they be ipso facto at any point in time automatically refugees under 1D2. They would need, if they left the West Bank, I think I was asked this question by Dana, I think in the very first seminar, if somebody leaves the West Bank and claims a well-funded fear of persecution for conditions in the West Bank, they would be assessed, and they're not UNRWA refugees, they would be assessed in the same way any other refugee from any other place in the world would be assessed, right? So that's a first important distinction that large parts of the Palestinian population are UNRWA refugees. Of course, people who were displaced in 48 and ended up outside UNRWA's areas of operation in North America, in South America, in Europe, in the Gulf, Egypt. Quite a few have ended up in those spaces, were to begin with not eligible for UNRWA's protection assistance because they're not in UNRWA areas of operation. They never were. So it's not that they had protection and it ceased. They were never eligible in the first instance, and so they fall into general categories within those states. In many instances, those people by now will have acquired citizenship, or their descendants would have acquired citizenship of those countries. Although famously or infamously, the Gulf, for instance, some of the countries, the ability to obtain citizenship is nearly impossible. And so there have been quite a lot of Palestinians who ended up in the Gulf, never became citizens. And again, famously, in 1990, when the first Iraq war, the first Gulf War happened, and Iraq invaded Kuwait, and the Palestinian leadership was deemed to have supported Iraq and not Kuwait. Kuwait proceeded by expelling after the war its Palestinian population. Many of them found themselves in Jordan and other places. So the precarity in places outside UNRWA's areas of operation is also something that we need to bear in mind. Although, let's say, in countries in the global north, in the West, broadly speaking, Palestinians who ended up there, their descendants are very likely to by now be citizens of those countries. So that's the
Can I
question.
ask?
Sorry, yes.
Sorry. How come UNA doesn't operate in Egypt?
Because
If they're operating in Jordan and Lebanon, why not Egypt?
that's a fantastic question to which the answer is political. Because when the UNRWA mandate was negotiated and the resolution was passed, Egypt was very strongly opposed, and I've read papers to that effect. I in fact cite it in my paper that was published a few weeks ago. Egypt was strongly opposed to having UNRWA presence and having a sustained population of Palestinians in its territory. So there's no, and you are absolutely right. It's the
Were
one
they
thing.
opposed?
Sorry,
Why were they opposed? What reasons did they give?
because they didn't. Well, as I say, I don't want to get too political, but fundamentally, they didn't want to end up in the way Lebanon and Jordan and others did. They didn't want to end up with the Palestinian population long term without a resolution. That's that's the that's the simple answer, right? They didn't and they don't, right? And as reflected in their approach to the closing of the Gaza border during the last two and a bit years, or
Yeah,
most of the last 2 years. But your question is, entirely valid, right? In the sense that there are two territories ultimately where in the region, in the immediate region to that space where UNRWA doesn't operate. The first is inside Israel itself, and that was because Israel did not want it to operate, because there were some Palestinians, people will know, although I don't know how well taught it is nowadays, but that there was some internal displacement within um, uh, what has become Israel. There's some villages that were internally located to other, or people who were not allowed to remain where they were, but they're still within the territory of Israel. There could have been arguments for certain um, areas of operations of UNRWA to include Israel, but Israel didn't want that. As we know now, Israel doesn't allow UNRWA to operate as of last year in East Jerusalem as well, even though because Israel deems it to be part of Israel. under international law, it is one of UNRWA's areas of operation because it's deemed to be part of the West Bank. And that creates its own tension and friction and challenge, which we can come to later when we think about the ramifications of interruptions, I'll put it mildly, to UNRWA services and what they mean for eligibility for refugee status. So I'll return to that theme, which is an important theme. But your, as I say, your point about Egypt is well put. Um,
Thank
so
you.
so let's now go blow by blow, as you were, and look at the content of Article 1D and at the different elements, and I've highlighted the bits that we want to be unpacking. So the first question, so if we look at this slide, we can see the convention shall not apply to persons who are at present receiving from UNRWA, let's say. So how do you understand this term at present? What do you think can be the two, if as a lawyer, right, what can be the two interpretations of at present receiving when you're reading this text?
Can you go back to the definition?
Yes.
I think it's either when they ask for asylum or when the article was erected. I mean, when they wrote it.
Exactly. Right. So it's either what we call a historically bounded definition. So it either is frozen in time in essentially the date at which the convention came into effect at the latest, right? If not the date in which it was signed. Um, and like freezing, taking a snapshot of whoever was receiving protection or assistance then, saying those persons and only those persons are excluded, which means oh, still only those persons will, under certain circumstances, be included under 1D2 if that protection or assistance had ended. That would entail effectively that about estimates vary, but about 100,000 people would fall under the exclusion clause in 1D1, right? So it's of those 700,000 people, most of them have passed away, so about 100,000 people remaining. So that's the historically bounded definition. That's the one that used to be held by countries, including the United Kingdom, as late as the 2002 El Ali case with Lord Phillips' judgment. It's also a position that is a minority position in the scholarship and literature. So famously, I think one of the books on your reading list, Jim Hathaway and Michelle Foster, believe that that's the correct way to think about Article 1D because ultimately they see it as an exclusion clause and they say we need to interpret, if we have two alternative interpretations, we need to go for the narrow one. The alternative interpretation is a continuative interpretation. Essentially, it's saying we are applying the convention at the time we are applying it, right? The convention wasn't frozen in time, certainly after 67 with the removal of the temporal dateline, with the fact that anyone at any point in time can be a convention refugee. And so it's an assessment that has to be made when you are determining whether the person should be excluded and ultimately also whether the person should be included in certain circumstances to avoid a protection gap. And there are various reasons why people take that view. I mean, one, it serves the object and purpose of this treaty because the treaty is not frozen in time. The treaty is an ongoing document. It also means you're less likely to have a protection gap given the countries in which UNRWA operates are not signatories to the Refugee Convention. What it would mean is that you have people who might be refugees who fall without any form of protection. And ultimately, there is that, as I said, the slight ironic or counterintuitive element to the definition, which is the more people get excluded, the more people are potentially eligible for inclusion under Article 1D2. And that is the position the Court of Justice of the European Union, and as a result, binding at the time and since on the United Kingdom in its interpretation, has adopted in the Bobo case. It's the position of UNHCR, and it is the position of most people, or most of the scholarship, right? So that's the first interpretive question. What does it mean to say at present? The second interpretive question is, what does it mean to say receiving? So again, to go back to the definition, it says the convention shall not apply to persons who are at present receiving from organs or agencies of the UN. Now, you might say that shouldn't be as difficult an interpretation question, because receiving surely means you are receiving. But on that again, there are two divergent interpretations. The interpretation the UNHCR adopts is that people to which this provision should apply are not just people who are eligible, who are receiving protection from UNRWA, but also people who are eligible to receive protection from UNRWA, even if they haven't claimed that yet, right? So say you've got someone who lives in Jordan, they live in Amman, they have a Jordanian spouse. They at the moment don't feel that they need to register with UNRWA, even though they're eligible, because they're the child of a male Palestinian refugee. They haven't registered, but at some point they might, right? UNRWA's position, UNHCR's position is they maintain that eligibility, and so they should be, as you were, excluded, because that would allow them to be included in 1D2 should that protection no longer be eligible, no longer be available to them. They say it would be incompatible with the object and purposes of Article 1D to remove from its scope Palestinian refugees who haven't accessed UNRWA protection despite being eligible, but are nonetheless in need of protection because of 1D2. So the scenario they have in mind is that somebody is in that position, and then for whatever reason they need to leave that area of operation, and UNRWA stops operating, right? And so the position UNHCR takes is that that person, if they were to return now, even if they wanted to be protected by UNRWA, they couldn't be protected because UNRWA stopped operating. They should enjoy the consequences of that termination or disruption to UNRWA's services, rather than be excluded ultimately from those consequences, right? That's UNHCR's position. The position in the case law in the European Union, and in fact in most jurisdictions, is a different position, is a narrower position, perhaps a more literal position, which says that only those who have actually availed themselves of the assistance provided by UNRWA come within this clause, because ultimately you are attesting in order to assess whether the protection or assistance has ceased for that person. Surely what you need to know is whether that person had assistance in the first place or protection in the first place. I have to say I personally agree with, so whilst I agree with the approach that says at present should be interpreted in the present and not in 1951, I at the same time on this point agree with the Court of Justice that it should be based on actual reception of protection or assistance, and not just simply on eligibility, given that it's not a particularly onerous thing to register yourself for services. And if people choose not to do so, then that may have consequences. But I don't think the convention definition is where those consequences need to be addressed. So that's a big debate, right, around Article 1D1, which has a direct effect then on Article 1D2. So we move to Article 1D2 to consider now its ramifications. And Article 1D2 says when such protection or assistance has ceased for any reason, without the position of such person, as I said, being definitively settled, which is the case, right? So if we are assessing any case of a Palestinian in 2026, that is the situation we find ourselves in. The position of Palestinians hasn't been settled based on UN resolutions. We may like or dislike that factual situation, but it is the case. In those circumstances, these persons shall be ipso facto entitled to the benefits of the convention. So what does ipso facto mean? It means there is no separate assessment that has to be undertaken based on Article 182. So you don't need to assess if somebody leaves, say, Jordan, because for them, protection or assistance is seized, whether they have a well-founded fear of persecution for a convention reason. They're essentially deemed to be people who are in need of protection, which is why protection was granted to them in the first instance. That protection has now fallen to the wayside. Um, that's why, as I'm about to say, for any reason actually is interpreted more narrowly than for any reason. If that is the case, if something has happened that meant protection or assistance for them has ceased, then they don't need to undergo an ordinary Article 1A2 assessment. They are nevertheless still subject to cessation and exclusion, right? So it is still the case that if they committed a war crime, for instance, they would be excluded from status, or at least the analysis, as we saw in the first section today, of whether they should be excluded would be undertaken. And if they have another nationality, for instance, we haven't studied cessation yet, we'll do that tomorrow. But if they have another effective nationality, which many Palestinians would have, right? So, for instance, if you've got that Jordanian person and they have Jordanian nationality, then they fall under the cessation clause. They don't need to get refugee protection, right? So, barring those circumstances of cessation and exclusion, they would be automatically convention refugees, and they'll be convention refugees essentially until there is a resolution of the Palestinian situation in the way the UN General Assembly resolutions require, or some other cessation clause applies. So, for instance, if they get refugee status in the UK and they become UK citizens, then they stop being convention refugees because that's one of the conditions under which cessation would apply. So I said the provision says protection or assistance has ceased for any reason. So let's consider someone who was registered with UNRWA in Jordan, received some welfare assistance from them, and goes on to study in Germany. They get a visa, they get a student visa to go and study in Jordan. Nominally, they left UNRWA's areas of operation. For them, protection or assistance has ceased, right? The provision says it has ceased for any reason. They should be refugees. The interpretation of international bodies, including UNHCR in this case, is that the answer is no. That if someone has left for reasons of personal convenience, then that doesn't amount to a to cessation to an interruption, or rather a seizing of the protection or assistance. So if somebody chooses to leave an UNRWA area of operation under conditions that are deemed to be voluntary, right, where the conditions, they haven't been pushed out, but they choose to go somewhere. If somebody goes on to marry someone in another country, right, they go and live with them in family unification, then that doesn't qualify for the for any reason component of this provision, right? Which is again an interesting interpretive move, by no means an obvious one, right? Because the literal interpretation of the convention talks about looking factually. Did they have protection? Has it ceased? Has it ceased? If for any reason they should be protected, the jurisprudence says no. Right? Jurisprudence essentially brings us back to an understanding of forced migration. And so UNHCR's guidance on this suggested there are four types of circumstances where the seizing of protection or assistance would be deemed to meet the condition under Article 1D2. The most straightforward and obvious one, and one that, of course, various political actors would want to see happen, is a full termination of UNRWA's mandate. So if UNRWA were to not be able to operate at all because its mandate were to be terminated tomorrow morning, automatically any Palestinian who, let's say, was receiving protection or assistance from UNRWA in one of its areas of operation, if they ended up in any convention signatory state, would be automatically a convention refugee in that country, unless they committed a war crime, etc., or they have another nationality, right? So potentially 5 point something million people, if they were able, of course, goes back to our first seminar, how easy is it to get somewhere? They were able to get somewhere, and tomorrow morning UNRWA stopped operating entirely because its mandate was terminated. That is an obvious application of Article 1D2. A equally obvious understanding, at least in the literature and in the jurisprudence, is if UNRWA is unable to operate in one of its territories. So UNRWA's mandate continues, but it is entirely driven out of a certain area. Say it is entirely unable to operate in Syria, which was the case for in certain areas of Syria during the civil war. UNRWA was simply not able to operate. At that point in time, if people had left UNRWA area of operation in Syria and say went to Turkey and further on into the European Union, arguably they would automatically be convention refugees in this country. And I'll come later to Gaza, which is the more obvious concrete example now. And as I said, the question of East Jerusalem as well. So that's the second kind of type of situation. If UNRWA nominally has still a mandate, but it's simply unable to exercise that mandate in one of its areas, if you are from that area, there is no expectation, at least at the moment, right? The jurisprudence may develop as the years progress. I would anticipate the more cases there are of this nature, the more there will be an attempt to suggest that people who cannot be in one UNRWA area of operation should try and go to another. Of course, that's not always possible. And it's not always possible because of point four, because if you are a Palestine refugee with a document of registration from Gaza, there is very little chance, if any, that you would be allowed, even if the United Kingdom wanted you to go to Jordan or to go to Lebanon. Why would those countries allow you in? So you would fall into category 4 here. There would be practically an impossibility of people to return to that country. That also happens to so-called refugee surplus situation, right? So you might have a Palestinian, take again my example of a student, but think about a student from a refugee camp in Syria, a Palestinian student from a refugee camp in Syria, registered with UNRWA, left for Germany in 2010, finished their studies in 2013, cannot go back to Syria. If that is the case, it's not a fault of their own. It is true that when they left, it was on their own volition. They now can't go back. Practically, that is the assessment the German state makes. They are automatically convention refugees, right? So if there are practical, legal, or safety and personal security barriers that prevent them from returning, that would also amount to an application, a triggering, if you will, of Article 1D2. And then the middle provision that I have left out in our discussion thus far is when people face threats to their life, physical integrity, security, or liberty. And that's why they're pushed out. So imagine if there is a woman in a refugee camp and she's suffering gender-based violence and she feels There is no way for her to be protected in that space. No one is offering her effective protection, and she flees and she leaves UNRWA's area of operation Italy and manages to get somewhere else. Again, as we know, the big challenge for Palestinian refugees would be to get somewhere, which would apply Article 1D2. But if they got somewhere, they would arguably be able to persuade a decision maker. They didn't leave because they wanted to, they left because they had no choice, because they faced serious threats to their life, physical integrity, security, or liberty. These circumstances, of course, are alternative. They're not cumulative. So it's enough to repeat the point I've made for UNRWA's mandate to be terminated, for a triggering in relation to, at the very least, everyone who is already registered with UNRWA services, for UNRWA services to be automatically entitled to refugee protection, except for people who are excluded or who have other nationalities, right? So if that were to happen, it's not on the cards immediately, but if it did happen, that would be the immediate consequence legally. Similarly, as I said, the inability of UNRWA to operate in certain areas has an immediate legal effect of making it arguably the case that that anyone leaving that area where they can no longer operate practically becomes a convention refugees, and that really was the case that the Court of Justice of the European Union was asked to determine um, and has in June 2024. You will note the date. Of course, this is about 8 months after October 7th. But the case originated before October 7th. So the case was of people who left Gaza, I believe in 2021, a woman and her daughter. They were both registered with UNRWA. They made it to Bulgaria in some way, and they applied for refugee status in Bulgaria, arguing that the equivalent provision within EU law of Article 1D2 applies to them. That is, that they had to leave UNRWA's area of operation. At that point, he was, of course, well before October 7th. So they nevertheless argued that for them, the conditions in the area they were in Gaza were such that they had to leave because they couldn't get UNRWA services. Right. So the question the court dealt with, because it's a court on a European level, was not the factual question for those specific individuals. So it wasn't going back to ask the question of in 2021 what was the case. That's a matter for the domestic court and for the decision makers. The question for the court was the legal question, which is what amounts to saying that UNRWA is not able to operate in a certain area. So we've got two people. They were a stateless person of Palestinian origin. They used to live in Gaza. They claim they must be granted refugee status. And so the question for them was, do they fall into 1D2? And so the court starts by saying this is an issue of an obvious importance and sensitivity, particularly in the light of the events that have taken place since Hamas's attacks. And it's the question, the legal question is, can UNRWA's protection or assistance be regarded as having ceased in the light of the living conditions in the area without it being necessary for the individuals to show they are specifically affected by reasons or factors that are particular to them? In other words, can you make a generalized observation about UNRWA's ability to operate in parts of one of its regions of operation? So say parts of Gaza, in the whole of Gaza, again, applicable to the West Bank, given East Jerusalem is seen to be internationally as part of the West Bank. Can we say UNRWA is unable to operate in the West, in East Jerusalem for the purposes of people who received protection or assistance from UNRWA in East Jerusalem? Can we say they don't need to demonstrate individually the effect of them, but rather we can make a generalized interpretation or assessment of the conditions under which UNRWA operates? So if you analogize it to some of our other discussions in refugee law, do you need an individualized assessment, or can you also have a form of a general or group determination in terms of conditions? And the court proceeds to say, firstly, that it is common ground that the fate of the beneficiaries of protection or assistance provided by UNRWA has not been definitively settled until now, right? So it deals with that middle part of the paragraph and says, again, without getting into politically why that is the case, the court says, when we have to assess this case in terms of the need for protection, that is the reality we're faced with, right? That part of the provision applies. And so we proceed to see the other bits of the provision. And so the court says the equivalent provision to Article 1D2 applies when it becomes evident based on an assessment on an individual basis of all the relevant evidence that the personal safety of the stateless person concerned is a serious risk and that it is impossible. So the test they set here, when it comes to individuals, that it is impossible for UNRWA, whose assistance was requested, to guarantee living conditions that are compatible with its mission. So UNRWA, it's not that UNRWA doesn't want to provide protection in a satisfactory way, UNRWA is simply unable to, right? And the person, as a result, is forced to leave UNRWA's area of operation owing to circumstances that are beyond their control and independent of their volition, right? That's the first category. That's an individualized assessment, and that is assessed based on the ramifications for that individual of UNRWA being unable to provide them protection. But there is also a situation where you can consider UNRWA's protection or assistance to have ceased within the meaning of the provision when the body finds itself unable, for whatever reason, the court says, so whether it's legal, whether it's stopping its funding, right? So, one reason UNRWA struggles to operate might be that it's legally unable to operate. Another is that it would want to operate. It has money. Sorry, it has the legal capacity to operate, but it has no money to operate, right? If it has no money to operate, it can't operate. That will have the same ramifications, right? So, and of course, if the general situation in that area of operation, for instance, a very intensive armed conflict, right, means that it is unable to operate in that area in which the stateless person has their habitual residence, if in those circumstances UNRWA is unable to ensure to that person, taking into account, this is where you try to individualize the general assessment, their state of vulnerability, dignified living conditions consistent with its mission, without them being required to demonstrate they are specifically targeted by the general situation, by reasons or elements specific to their personal situation. So this is a way or an attempt by the court to combine the individual and the general, right? It's essentially to say you don't need to show you are particularly targeted by any measures that limits UNRWA, but it is relevant to ask the question whether you are particularly vulnerable to the ceasing of operation of UNRWA. For instance, if you were relying on UNRWA for various life-saving medical treatment, or if you had a specific educational need that only UNRWA schools were able to operate in that area, but other schools weren't, right? So there might be situations where UNRWA has to not fully cease its operations, but has to cut back its operations. It
But
has to only provide, just 1 second, it has to provide only limited emergency operations. That might have different effects on different people. So some people might have not needed services from UNRWA that go beyond those emergency services, then they might not be eligible for refugee status, but others that were taking it, making use of UNRWA services, those people would get protection. Yeah, go ahead.
I don't fully understand how UNRWA ability to to provide education or medicine assistance is relevant for refugee status when if we're talking about just a random country that cannot provide education or medical assistance, it wouldn't be the basics of receiving a refugee status, even in times of war, and especially if we see UNRWA as like a mini state, someone who's supposed to
So,
be to provide the same as a state. So why does it different here?
so the short answer to this is that the standards that is applied is different in the sense that you, so you are right that if a state, so I'll qualify, I think the answer to your question is qualified. If you've got a country where only a certain section of the population is denied access to education, and the reason they're denied access to education is, say, their religion, then of course those people would be eligible for refugee protection because that's a form of persecution. What you're saying is that if everyone in the territory is suffering in the level of their education provision, that ordinarily wouldn't be ground for refugee protection, and you're right. But that is why the standard for protection for the application of 1D2 is not persecution. The standard of protection is whether people had received protection from UNRWA based on its mandate. Its mandate was specifically to provide different forms of protection, including education, to Palestinians in those areas. If that protection ceases, then there is a protection gap that is specific to this group, right, and needs remedying, right? So that would be the argument that you are right that is a different standard that is applied to the standards that would be applied if an ordinary person. So you can even think about a concrete example. Let's say you've got two people you've got two people who live in East Jerusalem now. Let's say that's a good example, right? Concrete example. You've got one person who was from a family that was originally from East Jerusalem. They're not registered with UNRWA. They have no eligibility for UNRWA services. Um, and say their school were to close for some reason, and you've got someone who used an UNRWA school, and the UNRWA school now had to close because UNRWA is not allowed to operate. The first person would only be eligible for refugee status if you would say they are now not allowed to register into a different Israeli school in this context, and that is a form of persecution, right? But if, for instance, there's an area where no one is able to access education properly at a level that we would deem to be acceptable in another country, that may not be sufficient to give the refugee status. Whereas the person who received education in an UNRWA school, arguably by virtue of um, that school closing down because UNRWA is not able to operate, that makes them a convention refugee somewhere else, right? At least on one interpretation, right? So your question is good also in the sense that, of course, this is the position the Court of Justice takes. It hasn't used a specific example of education, so this is described, right, as you can see quite easily in in kind of broad terms of generality, but they don't go into the specifics. And it might very well be that if a specific example where all UNRWA services except education continue to operate, they might say, well, that's not sufficient because the mandate is broad enough that if some elements of the mandate can't be fulfilled, but most of them can, that's sufficient. If UNRWA is unable to operate vital medical services, for instance, it's very likely that that would be a basis for protection, right? So you're teasing out, I think, helpfully, right, the borderline cases or the cases where this provision may not fully apply. So I just want to just do the second bit of what the court here says. So the court says um, the conditions that have to apply essentially is that the person needs to be subject to those conditions in the country, in the area. And if the person would find themselves, if they were to return to that area, in a state of serious insecurity, taking into account their state of vulnerability, right? So arguably, based on your assessment, we might say just being denied temporarily access to education is not a state of serious insecurity, so it wouldn't meet this criterion. But maybe for someone with a special education needs, we would say would, right? So that's where the debate might lie. And UNRWA's assistance or protection, it says, must be in particular be considered to have ceased where, for whatever reason, the body is no longer able to provide to any person in the area um, dignified living conditions or minimum security conditions. So that's the standard the Court of Justice decides to apply to this. Now, you might say, where is this standard coming from? How does that standard match up to what we would ordinarily apply in refugee law? I mean, I think, these are good questions. Ultimately, the important thing to understand is that the circumstances of Palestine refugees are deemed to be different insofar as um, they um, they are almost seen as if they are in a holding pen, right? The fact that there is this bit in Article 1D2 that says this only applies until the position of Palestine refugees is settled, is intended to say this whole model is a model that is supposed to be temporary. Now, of course, refugee law more generally is also not supposed to be permanent. But here, I think the assumption when this was drafted, when Article 1D was drafted, was not that 76 years later, one would be dealing with cases relating to Article 1D. Certainly not the assumption then. It might have not even been the assumption in 67 when the protocol was adopted and the dateline restriction was removed. But we are in a reality where a lot of Palestinians continue to receive these protections and assistance from UNRWA. As I said, not all Palestinians, but very large numbers of Palestinians, and the ramifications. I think that's the point I've made, and this is where I'll stop presenting. The point I've made several times. The ramifications of preventing UNRWA from operating legally are quite significant, right? I think that's often a missing piece in the puzzle around Palestine refugees from a policy perspective, and not just UNRWA not being able to operate entirely, which is an obvious point. That's the termination mandate, but also cutting funding for UNRWA that mean that they can't operate in the way they did can have a direct effect on other states. Now, this might be, and again, I'm now going to be semi-political, it might be the reason, for instance, why it is in the national self-interest of certain countries in the world to continue to fund or to be able to or to support funding UNRWA because of the realization that if UNRWA didn't operate, somebody else would have to step in. If people ended up having to leave UNRWA areas of operation because they can no longer receive services from them and they go elsewhere, the circumstances in which they left would be such that would grant them refugee status, right? So that is part of the wider picture around Palestine refugees, and I mean, to me, the interesting thing about the Court of Justice judgment is and the Court of Justice kind of over the years is the attempt to square general concepts of refugee law, like the need for a degree of forced movement rather than people entering on their own volition, like the need to show that you would be like a forward-looking perspective, right? The need to show that you would be in a state of insecurity if you return, right? Which is implicit but not obvious from the provision, right? Because the provision says when protection or assistance has ceased for any reason, the person is ipso facto refugee. It doesn't say that you need to show the protection or assistance won't resume in future. But the Court of Justice essentially is applying a refugee law perspective to it. It's saying, I'm going to be forward looking about this as well. I'm going to look at what prompted the person to leave protection or assistance overseas, but I'm also going to look at what is the likelihood, if I were to return them now, that they could resume protection or assistance. If the answer is that they can, then they won't get refugee status, right? So it applies a degree of a cumulative, both backward-looking and forward-looking perspective, which many scholars, for instance, have said is not a correct reading of the provision, but is an attempt to square this provision with the rest of the convention, because it sits very uncomfortably with the rest of the convention for all the reasons that we can think of. And nevertheless, it is part of the convention, and it interacts with the convention. It interacts with the exclusion clause, with the cessation clause, and it interacts ultimately with the convention insofar as if somebody does get refugee status, then the rest of the convention applies to them, right? The rights under the convention, and the ability ultimately potentially to naturalize. So, more questions or challenges on this?
Yes, I have one.
Sure.
I was wondering, I have a big picture question about the precedent that UNRWA, the Palestinian refugee status, the special status presents, because I mean, the UNRWA is not, it's not a, it doesn't supposed to be just a political sort of arrangement. It's supposed to be a legal one, and one that's supposed to be coherent. So if in the future some other country, some other population has to move to another place, doesn't get any refugee or any care or citizenship from the state that runs to, then allegedly they're supposed to be given the same Palestinian treatment by the logic of by that logic, and if not, then it's very much seems less as a legal logic or moral logic, and more just really political.
So I think my approach to this would be to say that it's a combination. I mean, as all law, it has a degree of politics to it, right? But ultimately, it's certainly international law. But it's I think the way to think about it is that the issue already existed, right? When 51 Convention was drafted, there was already an agency, so UNRWA already existed, right? So that's in international law and in kind of domestic situation, institutions matter, right? So the institution already existed, it already had a mandate, and so the question was, do you essentially streamline the people who receive protection from this institution into the now new agency? So UNHCR was only established in 1950, so after UNRWA, right? Or do you let it operate alongside it and essentially draw a line under it, right? So because even though the provision, as you say, nominally there can be a new agency that would be established, there would be no justification today to set up a new agency, because the expectation would be that countries would actually provide protection or assistance to people, would meet their refugee law obligation. If they don't, the solution from a UN perspective would not be to set up a new agency, would be to insist that they do, right? The problem here was that because the agency already existed, the countries in which the agency existed, and this is where this is where I agree with you, there's politics involved. The countries in which those refugees were living, ultimately, Jordan, Lebanon, and Syria did not want UNRWA to be dismantled, or did not want individuals to fall under a general refugee definition. Of course, there wasn't one as a matter of, if there was an Article 1D, because the original convention was only about refugees coming from Europe, you could say they wouldn't have been refugees. but they would still, in the absence of UNRWA, need services, right? They would need health, they would need education, they need that. And those countries didn't want to provide those services. And so the existence of UNRWA that provided those services in the absence, so we took in 1951, by that stage, it was clear they're not going back, right? So it was clear Israel would not allow them back, at least not immediately. In the absence of that, those countries said, we don't want them to fall on us, right? Is our responsibility. We want the UN. This is a problem the UN, created. You need to resolve it, right? So there was a combination of law and politics, or law and politics reasons for this. It's a very unsatisfactory situation, right? Because it also means there is a degree to which people are, and this I'm happy to say on the record, like I think a degree to which there's an acceptance that I think is utterly flawed, that people can be second, third, fourth generation stateless persons in places like Lebanon. That the idea that you can remain without a nationality of your state of residence, which we wouldn't accept generally as a policy. As I say, the Gulf states have a similar policy, which is also equally problematic. Doesn't apply to as many people. There are not as many people there, third, fourth generation. And that would be unacceptable under ordinary refugee law. You would expect states at some point to offer refugees a pathway to naturalization. And Jordan, to its credit, did do that initially with Palestinians. So in the 50s, a lot of Palestinians who were displaced into Jordan did get Jordanian citizenship. So large part of the Jordanian population is Palestinian in origin, but is not stateless. They have Jordanian citizenship. But Lebanon hasn't done this, and Syria hasn't done this, right? And of course, Gaza and the West Bank are complicated because there was no state, or there is no state that was able to grant them citizenship, which is why um, the Court of Justice refers to them as stateless Palestinians, right? Now a debate, right? There is a state of Palestine that is being recognized by many countries. Does that still mean that they're stateless? Well, they are stateless in the sense of not having effective protection from their state. That would trigger a cessation clause, right? So to that effect, they are. But yeah, I think yeah,
Mm.
I think it's a problematic framework. My own view is that it would be wrong at this point in time to terminate the mandate for all the reasons that I've articulated. I think there is a legitimate demand of the states in which Palestinians live to give them citizenship. I don't accept, because there's no basis for that in international law, that granting somebody citizenship somewhere else weakens the right to return to Palestine, in whichever guise that happens. That's not how we generally think about being able to return. So if somebody is Iranian and got British citizenship, they should still be able to return to Iran if and when conditions enable them to. Imagine somebody left Iran after the Islamic Revolution. So I don't accept, say, as a scholar, I don't accept that as a justification. Most certainly not as a basis to deny people nationality. So my view is that should be the pressure point internationally. It's to demand that people get nationality, which also then comes with a full set of rights, which at the moment they don't have, right? So at the moment, in many countries in the region, some rights, some key rights are dependent on being a national of those countries. So if you're not a national, you're denied those rights. And if you can never be a national, then you're in that perpetual state of discrimination. Even if UNRWA provides you other services, you are ultimately living in a place where you're second class. So that is my own position, which can be challenged and attacked from different directions by different people, but I think would be a human rights approach to this group of very, very vulnerable people in situations where most of them are stateless. and most of them are denied some very fundamental basic rights. The best way to resolve it is for them to have those rights. That's how I would think about it. Other questions or comments from people? Is the framework clear? I think is the question I'd ask. Like, is it whether you like it or not is a different question, obviously, but is it to the extent it's a resolved framework, of course, because as we've seen, there are some contentious interpretive questions, but what I've tried my best is to present those interpretive questions in a way that's I think reflective of the debate. So if there are no questions, I think we might call it a day here. With a few minutes to spare. So I will see you tomorrow. We will talk about what happens once somebody gets refugee status. Having kind of skirted around this all along, we finally get to that point. So what sort of rights do they have? When does that status come to an end? What is the political meaning of that status? And what are the political ramifications of that status? And if we have time tomorrow, we'll also talk a little bit about some wider future challenges of refugee protection, how refugee law sits or doesn't sit comfortably with bigger displacement challenges like climate change and others. So we'll see how we do with time tomorrow. And then, as I said, Monday, we'll be zooming in on Israel and asylum seeker there. So I shall see you tomorrow.
Thank you very much.
Thank you.